All right, let's talk about a classic scenario. What happens when you promise to pay someone to drop a lawsuit, but then you find out their claim was totally baseless? Do you still have to pay up? We're going to break down the contracts case Fiege versus Boehm to see exactly how the courts tackle that sticky question.
So here's our game plan. We're going to slice and dice this case using the FRAC method. Facts, issue, rule, analysis, and conclusion. It's the perfect way to follow the court's thinking, step by step, from the start of the problem all the way to the final ruling.
Okay, first up, the core conflict. Every case really starts with a human problem, and this one is all about a promise that was made to solve one legal issue, but ended up creating an even bigger one.
And it all boils down to this one critical question. Is a settlement agreement still binding if the original claim is later proven to be totally invalid? I mean, the answer to this affects thousands of agreements made every single day.
So, to get to the heart of that question, we first have to get the facts straight. Let's dig into the story of the broken promise between Hilda Boehm and Louis Fiege.
Okay, so the story kicks off in 1951. Hilda Boehm claims she's pregnant with Louis Fiege's child. Now back then, she could bring something called a bastardy proceeding to establish paternity and get support. To make that whole thing go away, Fiege allegedly promises to pay her expenses. And for a while he does, but then comes the plot twist. In 1953, a blood test proves he is not the father, so he stops paying. He gets acquitted in court, and you'd think that's the end of it, right? Nope. Boehm then sues him for breaking their original promise to pay.
And that sets up two totally different stories. Boehm says, hey, we had a deal, but Fiege's defense is the really interesting part for us. He argues that even if he did promise to pay, that promise isn't enforceable. Why? Because a contract needs consideration on both sides. Both people have to give up something of value. Fiege's argument is that since the paternity claim was bogus, her promise not to sue was worthless. And if her promise was worthless, there was no consideration from her to support his promise to pay.
This whole mess brings us right to the central legal issue that the court has to figure out.
So here it is, the big question. Does giving up your right to sue, what lawyers call forbearance, actually count as valid consideration if it turns out your claim was wrong all along? Everything in this case hangs on the answer.
Now to answer this, the court didn't just pull a rule out of thin air. It reached back and applied an existing legal idea from Maryland law, the good faith test. The court actually looked back to a rule from a case way back in 1867, and that rule highlights one thing above all else: timing. What really matters is what the parties believed at the very moment they made the agreement. The fact that the claim is later disproven doesn't get to travel back in time and blow up the deal.
So the court fine-tunes this idea into a modern two-part test. For your promise not to sue to be valid consideration, you gotta pass both parts. First, the subjective part. Did the person making the claim honestly, genuinely believe it was legit? And second, the objective part. Was the claim itself reasonable? I mean, it can't be totally absurd or just made up out of nowhere. You need both, a true belief on the inside and a reasonable basis on the outside.
Okay, here we go. This is the most important part of our case brief. How did the court actually take that two-part rule and apply it to the messy, real-life facts of this dispute?
The court went through it step by step. First, did Boehm have a subjective good faith belief? The court said yes. Based on her testimony, they believe she genuinely thought Fiege was the father when she made the deal. Okay, so what about part two? Was her claim objectively reasonable at that time? Again, the court says yes. Before the blood test, there was no proof of fraud, and the claim wasn't ridiculous. So the moment of the agreement, both parts of the test were met. Check and check.
And this is the absolute core of the court's reasoning. Those blood test results, they were totally irrelevant to the question of consideration. The value of her promise not to sue was locked in the moment they shook hands back in 1951. What science figured out in 1953 couldn't invalidate the contract that was already formed. Just think about it. If you had to be 100% right for a settlement to be valid, nobody would ever settle anything. Any new piece of evidence could destroy the deal.
So, after running the facts through the legal test, the court was ready to make its final call.
And the court's conclusion was crystal clear. Boehm's promise not to sue was valid consideration because her claim was made in good faith, and it was reasonable at the time. Therefore, Fiege's promise to pay was part of a real, binding contract, and he was on the hook for breaking it.
So let's zoom out. What's the big takeaway here? Why do we still talk about this 1950s case in contract law classes today?
Here it is, the key principle. The law really wants to encourage people to settle their problems outside of court. But if those settlement deals could just be undone anytime new information pops up, nobody would trust them. This good faith rule gives us the certainty we need to make those compromises stick, as long as the original claim was honest and had some reasonable footing.
And that leaves us with a final thought to chew on. Think about how this idea of good faith forbearance works in our world today. You know, if you make a deal to settle a dispute with a business partner or a customer, that deal is probably binding, even if you later find out you were mistaken about some detail. The key, as Fiege versus Boehm teaches us, is all about the good faith and reasonableness of the claim when you made the deal